Good morning, Your Honors. The matter before the court this morning is the case entitled PeakCM LLC versus Mountainview Metal Systems LLC et al. Case number 24 AP 356. Representing the appellant PeakCM LLC is attorney Alexander LaRosa. Representing the appellee Atos International Inc. is attorney Shapley Smith. Seated at counsel table with attorney Smith is attorney Jeff Kaplan.
Thanks very much. And good morning, counsel. Thanks for your patience. We'll hear, of course, first from counsel for the appellant. Please come on up. And if you would, for the record, introduce yourself and identify your client before you proceed.
Good morning.
Good morning.
My name is Alexander LaRosa with the firm of MSK Attorneys. I represent the appellant in this matter, PeakCM LLC.
Thank you.
Thank you. I begin, this case concerns two decisions by the trial court, Judge Tor. The first was a denial of PeakCM's motion to amend its complaint. The second was a decision granting summary judgment to ATAS International, who I'll refer to as ATAS this morning. I begin with the trial court's decision on the motion to amend. It is PeakCM appellant's position that the trial court abused its discretion in denying the motion to amend. This court has set an extraordinarily liberal standard in considering motions to amend. This court has set a preference clearly articulated in Bevins, LeClaire, and others that that cases are to be decided on their merits and that motions to amend are to be liberally granted. The motion to amend here.
Don't most of those cases, though, have to do with the initial filing prior to the time that was had here before the motion to amend was filed?
I don't believe so, Justice Carroll. And I point particularly to LeClaire and Shahi v. Madden. In both of those cases, motions to amend, and I point specifically to LeClaire because it comes to mind. In LeClaire, the same trial court denied a motion to amend that this court overturned. And in so doing, the trial court articulated that there was some extra good cause standard because the motion came later in the game. And what's important is there are cases, this court has articulated as well, where motions to amend are available and it is not an abuse of discretion to grant them at trial, after trial, 6 days before trial, which is well after any deadline for pretrial motions and the close of discovery.
You know,
Did the trial court, oh, go ahead.
no, please.
Did the trial court here impose a good cause requirement?
We believe it did, Your Honor.
Did it expressly do that?
We believe it did. In the trial court's decision, I believe it's PC 8, printed case 8, the court says when motions to amend are made later, there is a need to prove cause for the delay. And the trial court sort of cited its own decision in Weatherly. I think it was Weatherly versus Gravel and Shea, but it's cited her own trial court decision in Weatherly. And in LeClaire, v. LeClaire, this court very much rejected that standard and said cause, I almost want to quote The Wire, but I won't. Cause does not factor into the Bevins or Fomin 4 principle standards.
But timing does.
Timing does. Timing is not irrelevant. I will agree with that. But in this case, we think the timing was appropriate. It was made before the close of discovery. It was made. I'm sorry.
A week before the close of discovery.
About 8 days. Yes, Your Honor. But it was made before the deadline for pretrial motions was set. And that is an important date in our consideration because the deadline for pretrial motions, this is a pretrial motion, that deadline is set under Rule 16.2 to, I don't want to say prevent injustice, but as a break point to generally establish, just adjudication of cases before that.
futility is an issue for us. We still we do recognize that. What's your position with respect to that question?
Thank you, Your Honor. The futility doctrine does come into play. It is judged on a Rule 12b-6 standard. It was not the basis of the trial court's decision. Of course, I acknowledge this court has the ability to affirm a decision on other grounds. As to futility here, it is the appellant's position that its amended claims would not be futile. I point to the principal issue in our claim here. And the principal issue is our client and the installer of this metal siding product followed what it was then publicly available as the installation instructions. Those installation instructions, in our contention, proved to be incomplete and inaccurate. Discovery established that there may have been what is called in the briefing a splice plate detail available to ATAS, but not made publicly available. And it is our contention that under the Limoges standard, the Limoges tort line of cases, that when dealing in business and making a representation that one is to rely on, if that statement is materially misleading and is relied on as intended, that gives rise to a tort. This court has not stated that that line of cases is barred by the economic loss rule doctrine, the sort of Limoges negligent misrepresentation line of cases. The last time this came up was in Mazziello Real Estate. In note 2, this court specifically declined to address whether or not the economic loss rule bars the, yes, Your Honor.
I'm
Yes.
sorry to interrupt you, but I want to get this in before you run out. Was there as I understand it, under the EBWS case, this special relationship that is what you're leading up to, I assume, that is claimed here has to do with this design defect that you mentioned, the splice plate that is an issue. But in EBWS, we actually talked about the fact that the party in that case had not only presented itself as having this sort of specialty, but the plaintiff also paid for services of an architect in the contract that they had. So the question I had for you is, was there a carve out in your contract for design services? In other words, did your opponents acknowledge in your agreement and then pay for design services? That's my question.
The answer to that is there was no design services agreement between PeakCM and ATAS. ATAS's product comes with a very clear instruction that says, go to our website for complete installation instructions. And the installer of the product and my client, the end user, both did that, both downloaded what was available, both downloaded the same things.
So your argument would be it was implicit.
It was implicit, yes.
You got any cases on that?
I've not encountered this fact pattern. And part of the reason I've not encountered this fact pattern, I believe, is because by the variances of the wind, this caused no third party or property damage. These panels blew off. And had they hit somebody or hit a car, we would not be having this conversation because the economic loss rule would not be
It
implicated.
reminds me of the John Hancock building in Boston when I was in law school, and it had a problem similar to this, only it was much taller and heavier.
And this court has not adopted what other courts have, which is some sudden or dangerous condition exception to the
Well,
economic
is it
loss rule.
agreed that, but for the splice plate, that none of these panels would have blown off?
Is it agreed between appellant and appellee? I would not agree. No, they will not agree to that. I think that is a dispute of fact.
Yeah.
I would not put those words in their mouth. May I ask how much time I have?
Yeah, you can ask. Sure.
6 seconds.
Okay, thank you. I briefly, I do want to stress one last point on the motion to amend. That discovery was ongoing, and then a point that we make in our briefing that I'll make before I sit down and reserve the rest of my time is that concurrently to this, ATAS was arguing that there was no prejudice to a late expert disclosure because there was no trial set, there was no jury draw set, and it was far off into the future. The court granted ATAS's motion, PeakCM stipulated to it because it believed that to be true. There was no prejudice. The court granted that motion for the late expert disclosure in June of 2023. There is clearly plenty of time for whatever additional discovery, we believe there was none, to be taken, and that this did not delay the matter. We believe that is further evidence of the abuse of discretion, and I will reserve the remainder of my time in response. Thank you.
Okay, thank you very much. We'll hear from counsel for the appellee, please. And if you would, for the record, introduce yourself and your client.
Good morning. My name's Shapley Smith, and I represent ATAS in this matter.
Thank you.
May it please the court. Let me just first turn to the question on the motion to amend. I'd like to address a couple issues that were raised in the argument by the appellant. First of all, the decision is clear. The trial court did not use the good faith standard. The trial court was very clear.
Good cause.
Excuse me?
Good cause.
Good cause, excuse me, yes. The trial court concluded that there was prejudice. That is a decision that is within the discretion of the trial court, and you have to show that the trial court abused its discretion. And our view is that the appellant has not demonstrated that fact. And I think it's important to think about the timeline here. Case was filed in 2020. It was amended. The complaint was amended to include ATAS in 2020. Discovery and depositions were done. Discovery was done in 2021. Written discovery. Depositions were done in 2022. And in December of 2022, when all of the information that would support the over 80 new allegations and 4 new causes of action were within the possession of the appellant.
Wasn't that the basis of Judge Torres' denial?
It was.
The amount of time that they've had that information?
Yes. I'm trying to point out why I think her decision was correct, Your Honor. And so my point is that there had not, it was not timely, but also the defense had been shaped by the allegations that had been made against ATAS.
Forces had been marshaled?
Excuse me?
Forces had been marshaled?
Forces had been marshaled. Are you? Yeah, yes, I believe that would be the correct the way to put it. But and this is not a situation like Leclerc. I believe that it's distinguishable, where the issues that were raised in the amended complaint were ones that had been addressed in the summary judgment motion. So they were really not at issue. So I think the prejudice question was legitimately decided, and you'd have to. I don't believe that it's appropriate to conclude that the trial court abused its discretion there. I think this is more like Gauthier than it is like Leclerc. I want to speak briefly to the issue around the economic loss rule. And I want to speak to the professional services exclusion. There was no relationship between ATAS and there was no contractual relationship between ATAS and PeakCM. And the notion that there was a service relationship is just unfounded. You can't find a factual basis for it. Now, there are some allegations that someone from ATAS came out and reviewed the project with the subcontractor and I believe with Weeman Lamphere, the architect, and that was done. But that was customer service. That was somebody coming out, seeing if they could help figure out how to solve the problem. And customer service shouldn't be seen as something that actually is going to create the professional services exemption to the economic loss
Does it
rule.
matter, Mr. Smith, if they had been paid by the appellant to appear, to come and give consultation?
I don't believe so because this was not a services contract. This was a
No, I'm just saying if they said, okay, well, come on out, we're going to pay for it, we're going to pay for your time, we're going to pay for your expenses and the like, would that create a relationship? sufficient?
I dislike engaging in hypotheticals because I find that it gets you in trouble. I like to live in the real world.
That's the best answer. Well, I'll take that one and
All right. So if you have any other questions, I believe that our briefing actually takes everything into account. So if you have any other questions for me, let me know. Otherwise, I'm just going to sit down.
Okay.
Thanks.
Thanks very much. How much time does the appellant have, please?
Appellant has 5 minutes and 1 second remaining.
Counsel?
Thank you for that. Briefly, I want to address a few points. I do believe if you look at PC8, that the trial court used an improper legal standard. Trial court judge very clearly states, when an amendment is sought at a late stage in the litigation, there is an increased burden to show justification for failing to move earlier, citing Weatherly v. Gravel and Shea PC. It's not the standard this court adopted in Leclerc. I think it very clearly rejected that standard. I think that's evident that the court is using the wrong legal standard and abusing the discretion in doing so.
You're not saying that can't be considered as a factor though, right?
As I read Leclerc, this court seemed to indicate that that cause, if it will, is not implicated and so is not a factor. I think timelines may be considered, but as I read Leclerc, that, the need for justification is not implemented in the consideration of the factors.
Right, but there's a difference between justification and something not happening. And here is an absence of action during a period of time, which the court then says is undue delay and prejudicial. That's somewhat different than good cause, isn't it?
Not the way I read the cases, Justice Eaton. Briefly on prejudice, the trial court speculated that there would be prejudice, but prejudice is not extra work. Prejudice is an impairment of your ability to litigate the case, your ability to defend your rights. This court in Bevins said any prejudice from a eve of trial amendment could be ameliorated by a continuance and granting the amendment with conditions. And so prejudice does not just mean that there's additional work or additional discovery or the case got more complicated. Prejudice means something greater, some deep impairment, and that's not present here, nor did the court conclude that. The court simply concluded there might be additional discovery. Discovery was ongoing. To the assertion that these are all brand new factual allegations, I push back against that. At PC 64, in ATAS's motion for summary judgment, they clearly delve into the disclosure of a splice plate, the disclosure of their design detail, the disclosure of what's on their website. They clearly brief that issue. It's clearly discussed in the context of products liability. But these are all facts that were well investigated through the discovery process. These were all based on facts that were uncovered during discovery. There was no surprise, nor none alleged, nor none found.
Then what's the reason then for waiting until 8 days are at the close of discovery if you did know that all that time?
The case was developing late. There were other considerations that I don't think I'm at full liberty to disclose for work product and attorney-client reasons. There was also a clear deadline as we understood it for pretrial motions and tried to move in accordance with those. I understand that forces had been marshaled, but forces were marshaled early. And that is a strategic decision. People often marshal lots of forces. They move for 12B6, they move for 12C motions, they take extensive expert discovery. They do many of these things that are then counterpunched with an amendment. This is the litigation process. And we appreciate ATAS's argument, but we disagree with it. Thank you.
All right, thank you. Thank you both. Please call a conclusion.